blame the foreigners, you apathetic fools. We can't even blame government. We get what we deserve and live with what we can abide. And that, plus the fact that most of us are comfortable, or we'd all move towards making change. The UK state no longer serves the people, but acts as local administrators to a global oligarchy. And the intention is to be effectively rid of the native English people while asset stripping the country. And such behaviour is entirely consistent with a state that is a servant of global finance, engages in unlawful foreign wars, is institutionally corrupt, has no moral scruples, and is engaged in high treason. Welcome to the show. I'm the OBJ. Right, so I'm going to kick straight off with an issue that I ran in a test broadcast, and it's something of great interest, I believe, and it slipped past most people. So on September the 13th, 2018, UK mass surveillance was ruled unlawful in a landmark judgment. The European Court of Human Rights ruled that the UK's mass interception programmes have breached the European Convention on Human Rights, and the court found that the UK's mass surveillance programmes, revealed by the NSA whistleblower Edward Snowden, didn't meet the quality of law requirement, and that they were incapable of keeping the interference to what is necessary in a democratic society. The landmark judgment marks, of course, the first ruling on UK mass surveillance since Edward Snowden's revelations. The case was actually started in 2013 by campaign groups Big Brother Watch, English Open Rights Group, and computer science expert Dr. Constance Kurtz, all in the wake of Edward Snowden's revelation of the ECtHR mass spying. Documents provided by Edward Snowden revealed that the UK intelligence agency, ECtHR, were conducting population-scale interception, and they were capturing the communications of millions of innocent people. The mass spying programs included Tempora, which is a bulk data store of all internet traffic, Karma Police, a catalogue which includes web browsing profile for every visible user on the internet, and Black Hole, which was a repository of over 1 trillion internet histories, including email, instant messenger records, search engine queries, and social media activity. The applicants argued that the mass interception programs infringed UK citizens' privacy, which is protected by by Article 8 of the European Convention on Human Rights, and that their population-level surveillance was effectively indiscriminate, without basic safeguards and oversight, and lacked a sufficient legal basis in the Regulation of Investigatory Powers Act, RIPA. So in its judgment, the European Courts on Human Rights acknowledged that bulk interception is, by definition, untargeted, and that there was a lack of oversight of the entire selection process, and that safeguards were not sufficiently robust to provide adequate guarantees against abuse. In particular, the court noted concern that the intelligence services can search and examine related communications data, apparently without restriction, data that identifies senders and recipients of communications, their location, email headers, web browsing information, IP addresses, and more. The court expressed concern that such unrestricted snooping could be capable of painting an intimate picture of a person through the mapping of social networks, location tracking, internet browsing tracking, mapping of communication patterns, and insight into who a person interacted with. The court also acknowledged the importance of applying safeguards to a surveillance regime, stating, in view of the risk that a system of secret surveillance set up to protect national security may undermine or even destroy democracy under the cloak of defending it, the court must be satisfied there are adequate and effective safeguard guarantees against abuse. So the government passed the Investigatory Powers Act, IPA, in November 2016, replacing the contested RIPA powers and controversially putting mass surveillance powers on a statutory footing. However, this recent judgment that this indiscriminate spying breaches rights protected by the European Court of Human Rights is likely to provoke serious questions as to the lawfulness of bulk powers in the IPA. Jill Kinnock, who is the Executive Director of the Open Rights Group, said, since we brought this case in 2013, the UK has actually increased its powers to indiscriminately surveil our communications, whether or not we are suspected of any criminal activity. She also said, in light of today's judgment, it is even clearer that these powers do not meet the criteria for proportionate surveillance, and that the UK government is continuing to breach our right to privacy. Silky Carlo, the director of Big Brother Watch, that also campaigned, said, this landmark judgment, confirming that the UK's mass spying breached fundamental rights, vindicates Mr Snowden's courageous whistleblowing and tireless work of Big Brother Watch and others in our pursuit for justice. Under the guise of terrorism, the UK has adopted the most authoritarian surveillance regime of any Western state, corroding democracy itself and the rights of the British public. This judgment is a vital step towards protecting millions of law-abiding citizens from unjustified intrusion. However, since the new Investigatory Powers Act arguably poses an even greater threat to civil liberties, our work is far from over. Well said. There's never been a state historically that hasn't abused its authority, and the UK is no exception. Shame on you that state that if you've done nothing wrong, you have nothing to fear. The truth is, if you haven't done anything wrong, then you shouldn't be being watched. And the problem with being constantly watched is that it forces us to modify our behaviour, and those are not the actions of a free man. You're listening to the OBG. OBG.